Hi, my name is Helen Ward. I'm the president of Kids First Parent Association of Canada, and I'd like to share a presentation with you about parent-child rights in education and what actions can be taken, including legal action. So just hang on while I get the PowerPoint up here. There we go. Okay, yeah, so this is our topic. This was presented with the Safe Education Alliance and Kids First Canada. So we're at info@kidsfirstcanada.org. Website's kidsfirstcanada.org. Thanks. Just some preliminary comments. If there's any errors, factual mistakes, please send corrections in. And I'm going to avoid certain terms that are used a lot these days. For example, left, right, center, conservative, liberal, progressive, traditional, woke, communist, fascist, Marxist. I feel these terms have, there's so many meanings. The meanings are so confused. They're used as a kind of tribalistic way now. And they divide and conquer us unnecessarily. So I'd like to seek common ground, and when that's not possible, to seek peaceful coexistence. We're going to be talking about conflict, and conflict in our families, in ourselves, in our community, in our schools is very painful. Generally, most of us, not all of us, we want to avoid conflict, especially with other parents and with school staff. It's just not comfortable, and it makes education hard. And we need to, and I will thank all who disagree with me or others, because when you disagree with us, you make us think more deeply. So our agenda today is the goals are to empower parents to make plans, to be honest about the challenges of legal action, and to give hope. Topics we're going to be looking at are: what is the problem? Some key terms. What rights do we have as parents and children? What happened? Why are the schools the way they are right now? And what can be done, including actions to take that are not legal action and also legal action. So what is the current problem in schools? Basically, it's conflict over instruction and learning resources related to sex and identity. The larger problem is that there is an escalating power imbalance between the state and parents. State agencies are increasingly failing to recognize and are even usurping parental authority, parental rights, and parental obligations. Parental child rights are therefore violated. I say parent-child rights because children's rights are tied to parents' rights. This is part of something called defamiliarization. So defamiliarization is an ideology. In this ideology, public funds are transferred away from family members and given to corporations and agencies that do services. It's about replacing the family with paid service providers. And in the defamiliarization ideology, there's a concept of shared responsibility. That phrase, shared responsibility between the state and parents for child rearing. And it's part of the broader neoliberal, neoconservative, globalist ideology that really kicked off in the 1980s. So some key terms. The state. And what am I talking about? Well, when I say the state, I mean agencies that are run by the government or are dependent on government funding. And in the past, most areas of life were not part of state activity. The state has expanded, and so now we have state activity in marriage, birth, death, orphanages, child protection, or family policing services, as it's called, education, university, libraries, community centers, pools, medical treatment, health, mental health, childcare, daycare. So the state has expanded its sphere. So there's an idea of contested beliefs. What's a contested belief? It's any belief which is widely disputed or contested. For example, does God exist? Are there gods? What about immortality? What about the soul? Morality, sexual morality. What are schools for? What should be taught? And even phonics and cursive writing can be subject to much debate and contestation. And what's happening is that more beliefs are becoming contested and disputed. For example, 4 plus 4, you might say it's 8, but some people now are saying, well, maybe it's not 8. What does that mean? So because even the existence of truth, including mathematical truth, is contested, and all that is fine. But it should be noted that in a court situation, courts are based on the concept that there is such a thing as truth and that we can uh, often discover it. That's why there's rules of evidence and um, requirements to speak the truth, because our court system, our legal system, is predicated on the notion that the truth does exist. So when we have diversity of belief, well, I mean, diversity is fun when it's about, oh, I could have pizza or kimchi or sushi or whatever, or different kinds of clothes and arts and dances and all that kind of stuff. But diversity of belief is harder because it means that basically that we disagree about many things. You think I'm wrong. I might think you're wrong. You might think I'm stupid or crazy. And we have basically irreconcilable differences about some matters. And when this comes to sex, well, sex gets everybody heated up, maybe more than some other issues, because sex is very personal and private for many, and everyone gets their knickers in a knot when it comes to sex. And we have many very different, deeply held beliefs about sex and identity. And diversity of belief also reflects in practices. And what I mean by practices, well, beliefs are expressed in related practices, things doing and not doing things. For example, saying, these are ways we express our beliefs. Saying thank you, shalom, God bless you, namaste. What are your pronouns? F. These are all ways we express beliefs. Also eating, we could be fasting, eating birthday cakes, or no pork, no beef, no meat, no alcohol. We could be wearing a niqab or a turban or a cross, or wearing black or white or orange. We could be using public symbols like flags, bumper stickers, logos. And in our other behavior, our practices express beliefs about money, power, sex, our body, earth, and other things. So beliefs and practices related to beliefs. Learning resources. What are learning resources? These are anything used to support learning in school. It could be books, displays, posters, handouts, assignments, videos, websites, brochures, lesson plans, magazines, newspapers, etc. Those are all learning resources. Another key term is the idea of state neutrality. So in Canada, the state is prohibited from having or endorsing beliefs. People who work for the government, of course, are entitled to have and endorse beliefs, but the state itself is neutral, and that's according to our charter, or how it's been interpreted. A little bit of our history that we need to know because it repeats. There's a history of colonization. You've probably heard of that. In the 1800s, devout Christians like Edgerton Ryerson, pictured here, set up the system of compulsory attendance in tax-funded state-run schools. And he also founded the residential school system for Indigenous Canadians. They sought to impose their beliefs on children, using the power of the state to do so. This was a colonization of the family, a colonization of the parent-child relationship. And this was before human rights laws existed. That's why this egregious violation of the parent-child and the family relationships could happen. So there is, in this school system, inherently from the beginning, there was discrimination against non-believers, non-Christian parents, and their children. And this discrimination ended after legal action against it. But now education leaders are again using coercive power of the state to impose contested beliefs and practices on children. didn't learn too much from the history, maybe. Also, school is a unique environment, and including and respecting all at school is difficult because the education system currently forces strangers who have incompatible, diverse beliefs and practices to associate intensely and for many hours and days and weeks for many years. School is not the public square where equals freely enter, express themselves, and leave as they choose. We've had compulsory school attendance laws since the mid 1800s. In 1872, that's when this law came into BC. And parents are required to entrust our children to strangers because of these laws. This is a form of coerced and not freely chosen association. Also, there's a monopoly on public funds for learning. The public schools get the vast majority of the funding. Independent schools get quite a lot less. Homeschooling gets basically nothing. So the cost of independent schools and homeschooling makes it not an option for many. And it's just simply unfair that one child's education and learning gets funded and another one's doesn't. The school system also has a monopoly on credentials given that children need for their future goals. So because of these monopolies and this overall situation of coerced attendance, the state has power over students and parents. And parents and children are a captive clientele. Questions about the first section, you can think about that. Now we're getting to what rights do parents and children have? We'll look at international human rights agreements, the Charter, the Canadian Charter, some Supreme Court of Canada and BC Court of Appeal judgments, and provincial human rights codes. So international human rights agreements, these two links here will get you to something called the Declaration on the Authority of Parents and Guardians in the Education of Their Children. And these documents list all these agreements and have quotes from the agreements that you will find very useful. The Universal Declaration of Human Rights says, the family is a natural and fundamental group unit of society and is entitled to protection by society and the state. Protection, not replacement. And it says parents have a prior right to choose the kind of education that shall be given to their children. So a prior right means that it's a more basic fundamental right than other kinds of rights. The Declaration on the Rights of the Child says that the best interest of the child shall be the guiding principle of those responsible for his education and guidance. That responsibility lies in the first place with his parents. The Convention Against Discrimination in Education says the state parties agree that it is essential to respect the liberty of parents to ensure the religious and moral education of the children in conformity with their own convictions. And it says the state parties, the Convention on the Rights of the Child, and the preamble says the state parties are convinced that the family is the fundamental group of society and the natural environment for the growth and well-being of all its members and particularly children. And recognizing that the child, for the full and harmonious development of his or her personality, should grow up in a family environment in an atmosphere of happiness, love, and understanding. And it says that state parties shall respect the responsibilities, rights, and duties of parents to provide, in a manner consistent with the evolving capacity of the child, appropriate direction and guidance in the exercise by the child of the rights recognized in the present convention. Why is this particularly important? Because it's not, rights don't actually exist. They are a legal fiction. And rights, as human rights advocates will tell you, they must be asserted. It's parents that are the ones, like children need help. They are dependent. And it's the parents who are the ones who assist the child and regulate the child's exercise of their rights. It's not the state, it's not the teachers, it's not the doctors, it's the parents who determine when their child is mature enough or capable of doing something, when their evolving capacities are suitable. to some particular action or decision. So it's parents, not other people, who do this determination. And again, the convention says state parties agree that the education of the child shall be directed to the development of respect for the child's parents, his or her own cultural identity, language, and values. In the Declaration on Elimination of all forms of intolerance and of discrimination based on religion or belief, the parents have the right to organize the life within the family in accordance with their religion or belief, and bearing in mind the moral education in which they believe the child should be brought up. Sounds nice. Every child shall enjoy the right to have access to education in the matter of religion or belief in accordance with the wishes of his parents, and shall not be compelled to receive teaching on religion or belief against the wishes of his parents or legal guardians, the best interest of the child being the guiding principle. Is that not crystal clear? The child shall be protected from any form of discrimination on the ground of religion or belief. Now, the Canadian Charter of Rights and Freedoms, here's one helpful resource for that. It's called Charterpedia. It's done by the Federal Ministry of Justice. There's the link if you want to help with interpreting the Charter and understanding it. So under Section 2 of the Charter, we all have fundamental freedoms. These include freedom of conscience, of religion, and religion is very broadly defined. It doesn't mean I'm a Sikh, I'm a Baptist. It could mean that, but it means any sincerely held belief connection to the divine. So maybe you don't have a particular denomination or something you belong to, but maybe you believe that you have a sacred duty, or that the Creator has given you a duty to care for your child and raise him in a certain way. That would be a religious belief that's protected. We have freedom of thought, belief, opinion, and expression. We have freedom of peaceful assembly, freedom of association. And that means we hang out with and we spend time with and get together with those we choose. And all these freedoms can be limited by the government, but only in a way that is reasonable in a free and democratic society. Section 7 of the Charter says everyone has the right to life, liberty, and security of person, and the right not to be deprived thereof except in accordance with the principles of fundamental justice. So what does this mean? Life means, well, you're alive or you're dead. Liberty, it has been interpreted to include a protected sphere of parental decision-making for parents to ensure their children's well-being. For example, a right to make decisions concerning a child's education and health. And security of person, what does that mean? It's our mental and physical well-being. So if a child's or a parent's or staff members has been harmed or distressed, mentally upset in some way by something that's happening in the school, that is a violation of their security of person. Section 8 of the Charter says everyone has the right to be secure against unreasonable search and seizure. And this is what guarantees our privacy and the privacy of our personal information and data, or it's supposed to. And the Charterpedia says the values underlying the privacy interests protected by Section 8 are dignity, integrity, and autonomy. Protection Section 8 provides for privacy is essential not only to human dignity, but also to the functioning of our democratic society. As such, Section 8 protects a sphere of individual autonomy within which people have a right to be let alone, and on which the state cannot intrude without permission, without consent. We'll be talking about privacy quite a bit here as we go along. Section 15 of the Charter is about equality rights. It says we have every individual is equal before and under the law and has the right to the equal protection and equal benefit of the law without discrimination, and in particular without discrimination based on sex, race, color, etc., and based on religion. The Supreme Court of Canada and BC Court of Appeal decisions I'd like to draw to your attention are next. So there's a very few cases related to parents and children in the state go this far, but few have gone. In this case, the BR case is very important. In that case, the Supreme Court of Canada found that The right to nurture a child, to care for its development, and to make decisions for it in fundamental matters such as medical care are part of the liberty interests of a parent. Parents are in the best position to take care of their children and make all the decisions necessary to ensure their well-being. Some of know all the decisions. The recognition was based on the presumption that parents act in the best interest of their child. The parental interest in bringing up, nurturing, and caring for a child, including medical care and moral upbringing, is an individual interest of fundamental importance to our society. Also, while parents bear responsibilities towards their children, they enjoy correlative rights to exercise them. You have responsibilities, you must have rights. Parents should make important decisions affecting their children both because parents are most likely to appreciate the best interests of their children and because the state is ill-equipped to make such decisions itself. We are celebrating right now at this time the Truth and Reconciliation Day, and we should remember the tragic history of Canada in which the state violated the parent-child relationship and caused horrific, tragic damage to thousands and thousands and thousands of people and intergenerational harm and damage that we continue to see every day in our country. So the state needs to mind its business and not attack the parent-child relationship and insert itself between the parent and the child. Children are unable to assert these charter rights, and so society accordingly presumes that parents will exercise their freedom of choice in a manner that does not offend the rights of their children. State interference between the parent and the child in order to balance the rights of parents and children will arise only in exceptional cases. The state can properly intervene in situations where parental conduct falls below the socially acceptable threshold. So again, this is about parents are the ones who determine the children's exercise of their rights. Parents are trusted. Another important case in this area is the Chamberlain Surrey School Books case against the Surrey School Board. So the school board must act in a way that promotes respect and tolerance for all the diverse groups that it represents and serves, all of them. The words secular and non-sectarian in the BC School Act imply that no single conception of morality can be allowed to deny or exclude opposed points of view. That parental duty includes the sole and primary responsibility to oversee all aspects of day-to-day life and long-term well-being, as well as major decisions with regard to education, religion, health, and well-being. This is consonant with the privileged parental role in the upbringing of their children. Another case, the Ross case against New Brunswick School District number 15. It's about the role of teachers. Public school teachers assume a position of influence and trust. Their students must be seen to be over their students and must be seen to be impartial and tolerant. A school board has a duty to maintain a positive school environment for all persons served by it, and it must be ever vigilant of anything that might interfere with this duty. Is your school environment positive for you? Has the board ensured that it's positive? There's the right of children in the school board to be educated in a school system that is free from bias, prejudice, and intolerance. Relevant to this particular context is the vulnerability of young children to the messages conveyed by their teachers. What messages are those? Same case. What this evidence discloses is a poisoned educational environment in which Jewish children perceive the potential for misconduct and are likely to feel isolated and suffer a loss of self-esteem on the basis of their Judaism. The state, as employer, has a duty to ensure that the fulfillment of public functions is undertaken in a manner that does not undermine public trust and confidence. How is your trust in the system these days? And it must ensure that the education services are discrimination-free. A BC Court of Appeal decision on related to teachers' political expression found that um, if teachers are permitted to use public schools as forums to advance particular political agendas, they will undermine an open and supportive education environment, and ultimately that will detract from the fundamental objective of the school system. Public confidence in the system is also of vital importance, as the proper functioning of the school system is dependent upon public support and, in particular, the support of parents. That was a case with the BCTF. Do they even care about the support of parents anymore, since they have a monopoly on most of the funding? Another case very relevant to our situation is the Kempling case. If a teacher acts in an improper way on or off the job, there may be a loss of public confidence in the teacher and in the public school system, and a loss of respect by students for the teacher involved and other teachers generally. And there may be controversy within the school and within the community, which disrupts the proper carrying on of the education system. Well, this seems to be happening right now. To hold an individual in contempt or to judge them based not on their actual individual capacities, but on stereotypical characteristics ascribed to them because they are attributed to a group of which the individuals are a member, is to treat that individual in a manner which is not consonant with their inherent dignity. Statements and actions based on such judgments are the hallmark of discrimination. I mean, I'm hearing that students and parents are being told they're not Canadian, that their beliefs and values are not welcome, that they can't bring those to school. Well, that's contrary to all these things we've just been discussing. Human rights codes in the provinces and territories, these are like Section 15 of the Charter. They prohibit discrimination in education and other services. You specifically cannot discriminate based on race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. And these other ones are not included in the Charter, but they're in the human rights codes. You can't discriminate based on family status. Well, what does that mean? If you're the parent of a minor child or the minor child of a parent, well, that is your family status. So discriminating against parents of minor children as a whole group is illegal. Assuming that parents are going to harm or be violent against their children, that is clear discrimination the way racism is. You can't discriminate based on marital status, for example, being a single parent, or based on sexual orientation, gender identity, or gender expression, or source of income. Now, these sexual orientation, gender identity, and gender expression, these definitions are somewhat unclear and they are expandable. They have been expanded, and they are also subjective, meaning these terms can relate to an inner state that is not objectively knowable, or not always, or it's complicated. What can I say? Wait, questions there? Let's stop the sharing. Okay, we'll just get back to our screen share here. You can think of questions you may have about the past and what we've done so far. Sorry. Okay. Okay. So our next section is about what happened. Why are contested beliefs and practices about sex and identity in schools now? So I'm going to talk about sort of a perfect storm of situations. There's about 7 factors. There might be more, but I've come down with 7 right now, that created this perfect storm. 1 is the escalating power imbalance between parents and the state, which I've discussed already. 2 is professional autonomy. 3, curriculum changes. 4, opt-out changes. 5, safety strategy changes. 6, learning resource changes. 7, unaccountable third-party educators All these add up to making opportunities for contested beliefs to be introduced. And I would say these all add up to the violation of the unwritten social contract between parents and the school system and the state. So the social contract has been basically torn up, and many people have lost confidence in the public school system or school system in general. So talked about the escalating power balance. So 2, professional autonomy. What does that mean? So professional autonomy is something that the BC Teachers Federation, that's a BC Teachers Union, has long sought and now has. It's a concept that is actually in their collective agreements. All but 2 of the 60 collective agreements have professional autonomy language in them. So professional autonomy allows the teacher to determine the planning, presentation, methods of instruction, and evaluation of course materials. So they can choose what materials they want to use. And their instructional methodology shall not be mandated. So they have a great deal of freedom to do what they want in the classroom. This was not the case in the past. Yeah. About the content that, there's curriculum content, but if you read the curriculum, it's quite vague, so it can be interpreted very liberally under professional autonomy. Now, school boards, this says, can challenge a teacher if they feel that their professional judgment has gone off. So school boards can, but basically don't, challenge teachers on what they do and what they bring into classrooms. And just regarding professionals, like professionals are sometimes defined as those who can be sued for harms that they cause in their professional duties. So doctors, lawyers, engineers, and accountants can be taken to court. And these professionals cannot practice their profession unless they have insurance coverage for malpractice or for doing something wrong in their professional responsibilities. Now, teachers do not have this level of accountability and individual liability for their actions. So they didn't used to call themselves a profession. My mom was a teacher when they pushed to be called a profession, I guess in the 1980s or so. My mom was against it, actually. We're not a profession. There we go. So what happened? Oh, there's the other thing is that the curriculum changes that happened. We're going to look at personal planning, the introduction of that, the Surrey School Books case, and the Corn Agreement, something you've probably never heard of. So in 1995, something called personal planning was added to the kindergarten grade 7 curriculum, and there's other courses, similar courses added as well. Currently, these would be called career education or career life education courses. They change the names often. So this was these newly required courses mandated that the routine violation of students and family members' privacy. What do I mean? All these courses are also required for graduation in high school. So the curriculum now requires students to reveal and discuss their own and their family members' identity, personality, beliefs, future plans, goals, private life, personal information, family structure, family life, out-of-school activities, relationships, diet, hygiene practices. How many showers have you had this week? How much exercise did you do? What did you eat last week? Many questions like these are just normal in schools now. So confidentiality and consent and boundary norms are routinely violated in school. Now, I would say this is a way of grooming students to be compliant to authority figures who are violating their boundaries, their consent, and their privacy, as well as their parental consent. And when children are required to discuss these things, these personal things, differences between students and families' beliefs and habits and practices are exposed because they have to be. Um, and that will create more conflict. There's more differences exposed, more conflict. So there's less common ground, and peaceful coexistence is more difficult. It's a way to divide and conquer people in the kids in the schools and the communities and the population in general. Don't you notice there's a lot of division? So in 1995, that personal planning thing got added, and so the curriculum required kids to discuss their family type, and this brought in an opportunity for contested beliefs. So in 1996, 1 year later, James Chamberlain, a Surrey kindergarten teacher and sex activist, sought approval from the school board for books depicting same-sex parented families. The books were on resource lists made by the Gay and Lesbian Educators, ALBC. The case went all the way to the Supreme Court of Canada, and the appellants were James Chamberlain and Murray Warren. So they were both teachers and sex activists. I don't have a problem with activists. I'm an activist or sex activist. Well, just using a term because that's what they are. And Murray Warren later became Murray Corin. So these are more recent curriculum changes. This has brought in something called valuing diversity as part of the curriculum. Whatever that means is what they say. It says, in particular, teachers should ensure that classroom instruction, assessment, and resources reflect sensitivity to diversity and incorporate positive role portrayals, relevant issues, and themes such as inclusion, respect, and acceptance. This includes diversity in family composition, gender identity, and sexual orientation. This is for all students, but they mentioned they didn't mention a whole lot of other kinds of diversity, religious diversity, belief diversity, cultural diversity, all been left out. So honoring diversity seems kind of truncated at the get-go in the curriculum. This is on the government website. So valuing diversity. So diversity of belief, conscience, religion, culture not mentioned. And as part of valuing diversity, teachers may, they don't have to, they may discuss human rights and human rights codes. Another aspect of the curriculum changes is these things called the 3 core competencies. And one of those is this competency called personal and social. So in this personal and social competency, all this, that's where a lot of this intrusion into the inner life and the personal state of the child and their family is conducted. Now it seems like identity construction is now one of the core purposes in the curriculum. So the construction of your identity is something that is paramount in the schools now, which it wasn't in the past. I guess we could have identities without the school working on that in the past. Yeah, so you'll see a lot of discussion about relationships and cultural context and like the child, sexual orientation, gender identity, age, geographic region, religion, spiritual beliefs. Explore who they are in terms of their relationship to others. Students define who they are by what they value. This statement is full of contested beliefs and assumptions. Students define who they are. I don't know, but there's a lot of philosophical, theological assumptions in that statement. They identify how their values help to shape their choices in all contexts of their lives. These are children, sometimes as young as 5 or 4. So there's emphasis on like basically the child, the student becomes the curriculum. So there's this focus on I, me, I I know my name, my identity, I can identify my life experience. Like let's very much focused on the child self. Here's some lesson ideas that the government provides. we can be different. Students identified differences between them and their classmates and created self-portraits. That's going to be fun. But how comfortable is that? Here, we are all related. Students present their personal interests, abilities, and family relationships on a poster and then discuss what they included and why it was included. So think about your family members up there. Did the family members consent to this inclusion or discussion? What if some children are in very difficult situations in their family? Maybe somebody died. Maybe their mom died. Maybe they're in foster care. Maybe, oh, there's people in the homes. Why should they have to discuss this in the unsafe, intrusive environment of a school amongst kids and teachers who they may not really know? What is a family? Students investigated the question, what is a family, and reflected on their own families. Right. There's many more examples in the curriculum. You can look them up. Another part of the changes is the health education. Now, what used to be PE or phys ed is now PHE, physical and health education. This is where sensitive topics are often covered. Sensitive topics can mean anything, but it usually means sex. So here, boundary and consent and privacy violation are routine, as in the career courses. We also see this boundary violation and consent violation in students being given surveys and questionnaires by UBC organizations, and they're being used, the students and their families are used as unpaid, unconsenting social science research lab rats in schools for about 20 years now. It's a form of data mining. They're data mining the kids and the families through the kids in schools regularly for years. Now there's some interesting contradictions in the new curriculum. Boundaries and consent are part of the physical and health education curriculum from kindergarten to grade 12 every year. But personal information and private boundaries are violated by the curriculum. And even in these research, social science research, they're often asked about their sex lives, about drug use, their emotions, their friends. Again, more privacy and consent violations, just routine in schools. And nobody seems to really notice this. Is quite a shocking thing. Here's the kindergarten PHE curriculum. You go to these, you need to click on these things called elaborations to get the full curriculum. Here, curriculum, boundaries, 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 consent, and curriculum, kindergarten. In grade 8, gains boundaries and boundaries and consensual intimate activities and boundaries and sexual consent and boundaries. Go. There's some quotes. Here's some quotes from the kindergarten physical and health education curriculum. This is what you're supposed to do. Recognizing behaviors used by abusers or groomers. For example, giving gifts, isolating a victim from their family. Has it ever happened? Using guilt or blackmail to control. Developing an initial understanding of consent, understanding personal boundaries and respecting the boundaries of others. For example, body boundaries and emotional boundaries. Ensuring affirmative consent. Yes means yes. And obtaining permission before doing things. Saying no and stop in respectful and assertive ways. Listening and respecting when others say no or stop it. I heard a lot of people say no and stop it recently regarding stuff in schools. Is anybody listening? In the grade 3 curriculum, the PHE curriculum, you're to learn what can you do to stand up for yourself in an unsafe and or uncomfortable situation. Removing yourself from an unsafe or uncomfortable situation. Cultivating awareness of power imbalances and how they can impact issues of consent and boundaries. What about the power imbalances in the classroom and the school? Are those discussed? I don't think so. Recognizing that personal boundaries may change over time and ongoing consent is required. For example, behaviors or play evolve with newer boundaries. Developing strategies such as using a strong voice to set boundaries and saying, no, stop it, I don't like this. Not giving out personal information, for example, to strangers on the internet. Those schools do this all the time, and they ask students to upload their personal information to the net all the time. So the third part of this curriculum changes talking about the Corin Agreement. Corin Agreement. Now, this is a really interesting and strange thing. In 1997, the Corins, a same-sex activist couple, launched a human rights complaint seeking representation of individuals and groups across the full range of gender identity and social and sexual orientation in the curriculum. And that took a long time, but then in 2006, without a hearing, the BC government made an agreement with Corans, and it's called the Coran Agreement, and allowing this couple, the Corans, to review all curriculum and resources for inclusion of same-sex relationships. So all courses, all grades from kindergarten to grade 12. So for some reason, these two guys were given the right or the power to review the entire curriculum, all resources, and to determine who can choose resources, who the resource selection organizations. And I'm not sure if this agreement is still in place. I suspect it is, though I don't know. Probably need a Freedom of Information request to get that. So what happened? There was these opt-out changes happening. So what does opt-out mean? Opt-out is when parents say, I don't want my kid learning about this, so I'm going to take him out. An option to take him out. The formal word is him or her or whatever. Alternative delivery. And it's usually for sensitive issues. And sensitive issues is not usually defined, but usually includes sex. The Corans were very opposed to parents being permitted to opt out their children from any teaching related to sex. Peter Coran said, there's no point in us making the curriculum more queer positive if people can take their kids out. Sorry, Peter. So the Corans were not successful in eliminating opt-out as they tried. Parents can still opt out their children from the sensitive issues taught in health and planning courses from kindergarten grade 12. But other changes happened. So really, there is no opt-out, and the Corans kind of did get their way. And this is through this other area, the anti-bullying safety strategy. So in 1996, a student named Azmi Jubran made a complaint to the BC Human Rights Tribunal against the North Vancouver School District. He had been terribly bullied for 5 years in high school, including being called homosexual slurs, according to the court record. He was not homosexual, and his bullies did not think he was. And the Human Rights Tribunal ruled that the district was responsible for the bullying. They had tried to stop it, and they had dealt with it, but continued nevertheless. And they were ordered to pay Jubran $4,500. But the district is financially liable only if a human rights code covered discrimination happens, such as sexual orientation discrimination. And because of those homosexual slurs used, the bullying was deemed to be under the Human Rights Code. If Mr. Jubran had been bullied, being called what, a loser, a jerk, those kinds of terms, those are not covered by the Human Rights Code, and this money might not have, this decision would have been totally different. It wouldn't have gone to court at all. So in the Jubran case, it was determined that a school board has a duty to maintain a positive school environment for all persons served by it. But the school board has a duty to provide students with an educational environment that does not expose them to discriminatory harassment. Is that what's happening for you and your children? And to foster the full participation of individuals in the life of British Columbia in a climate of understanding, mutual respect, and equality of dignity and rights. Wouldn't that be wonderful? Is this what's happening for you in your life with the school system these days? So this anti-bullying strategy thing came about. The Safe and Caring Schools coordinator for North Vancouver said the insurer for all school districts has made the decision to pursue the case to the Supreme Court of Canada because of limits on liability. So it was basically what we call butt covering. The districts need to cover their butts so they're not financially liable. So only Human Rights Code covered discrimination is going to be covered. And these policies were created, or the Safe Caring and Orderly Schools Guide, and then the Safe Caring and Orderly Schools Policy in 2004. The Supreme Court of Canada basically agreed with what happened in lower courts with the Jubran case. So, but bullying it's not curriculum. It's covered under school health and safety policies like earthquakes, pandemics, junk food. That's where it is, safe and healthy schools. Bullying is in there too. These are two students who were terribly bullied in BC's school system, Azmi Jubran, whom we've spoken about, and Amanda Todd, who I'll talk about now. So Amanda Todd was sexually extorted online by a Dutch child predator and then terribly bullied at her school. She switched schools and it just continued. Cyberbullying and in-person bullying. And in 2012, Amanda, at age 15, took her own life. It's a very high-profile case because Amanda made a video that expressed her situation. It was covered nationally, internationally. And so in response to that, in 2012, BC started the Erase anti-bullying strategy. So ERASE stands for Expect, Respect, and a Safe Education. Expect, respect, and a safe education. Do you have respect and a safe education now? Now, the codes of conduct, like the Jubran case, schools were required to put up codes of conduct, and that included all the human rights categories, and to have maybe like workshops and things like that. So if they followed those, put up those codes of conduct, distributed them, did some workshops or something, they were legally covered if there was bullying. But this did not prevent what happened to Amanda. Yeah. So here's the Erase page on the BC education website. There we go. It's every child deserves an education free from discrimination, bullying, harassment, intimidation, and violence. The Erase strategy is helping ensure every child feels safe, accepted, and respected. Is it helping your child? And then in 2016, our Human Rights Code was amended and our BC politicians voted to include gender identity and gender expression in the Human Rights Code. It's 2016. Or 2017, SOGI, sexual orientation, gender identity, is added under the Erase strategy because it was added to the Human Rights Code. So erase discrimination, and there you go, SOGI's added under that. And this, then it makes a statement that everyone has a sexual orientation and gender identity. That's a statement. That is a belief statement. It's a contested belief statement. The terms sexual orientation, gender identity, all these terms and the combination of these terms are all subject to a great deal of thought in thought systems, philosophies, theologies, and they're contested. Those terms the meanings are not agreed on. So this is under the anti-bullying and safety strategy. So a strategy is not curriculum. Like teachers must teach the curriculum. It's not curriculum, so teachers do not have to teach it. Teachers can choose to teach SOGI as part of valuing diversity and as part of the Human Rights Code, but they don't have to. Remember, they have professional autonomy. What would happen if SOGI was required under the curriculum? Well, then you might have some teachers actually stepping up because they would be required to do something that many of them might not, that would violate their beliefs. So the government hasn't pushed teachers into violating their beliefs. They can choose not to discuss this if they don't want to, but it's forced the students to deal with teachers who do want to teach it to them. So remember the concept of state neutrality. The state is not permitted to have or endorse beliefs. And these are all contested beliefs. And schools are state agents, so we have schools violating this all the time. Another change that happened was changes to the learning resource selection policy. What does that mean? Now we're going to go into 3 areas: the individualization of the process, addition of SOGI 123, and privatization of the learning resource selection process. In 2017, the BC government offloaded the selection of learning resources to district boards. Like in the past, the government department collected lists of books and resources and films and everything else for it to be used in schools, and teachers would select from among those resources. But now the provincial government isn't doing that. They're dumping it onto boards to determine the selection process. It's a lot for boards to deal with. What do the boards do? They dumped it onto this responsibility onto individual teachers and or principals. So every school board has to have a policy about learning resource selection and also appeals, which means complaints about learning resources. And most of these say that the teacher, with their professional autonomy, or the school personnel, the librarians, or whatever, can choose what they want. Some of them put the responsibility more on the principal. But there, it's all been individualized. It was not a government thing. It's individual teachers and principals and counselors and whoever's in the school system can bring in whatever they want. So what's the impact of individualization of resource selection process? Well, parents and students cannot know what resources will be used in the school. There are no standards. It's a total crapshoot. But what your student will encounter when they step into a school or even onto the school grounds. Education personnel are free to choose virtually any resources they see fit according to their professional autonomy. And parents and students are then forced to make formal complaints and appeals to address these concerns. And parents and students are not well equipped to do this. We don't have the time, money, resources, energy to deal with every single teacher making their own decisions about all these items. So what happened? There's changing to the learning resources. The Ministry of Education decided that the SOGI aspect of the erase strategy, needed learning resources. Like, we don't have learning resources for what religious identity, spiritual identity, economic orientation, but we have them for SOGI. So these learning resources, so that's why we have SOGI 1, 2, 3. It's resources. It's a bunch of learning resources, books, videos, posters, whatever. But they're optional because it's not curriculum. Remember, it's not curriculum. And teachers don't have to use SOGI 1, 2, 3 resources. Teachers who want to can use them. So what is SOGI and SOGI 1, 2, 3? Neither of those are curriculum. They are optional. They don't have to be used. They may be used in health and career curriculum or any other courses, but they don't have to. This is the government links to these descriptions. And so this privatization of the selection process. So this ERAC was the government's learning resource selection branch, and it approved the SOGI 1, 2, 3 resources. It said that these resources have been formally evaluated as age appropriate and aligned with provincial curriculum and evidence-based educational approaches. I'm not sure what evidence they use, but there you go. They're age appropriate and aligned with these. That was in 2017. So in 2019, the government put that government body, the ERAC thing, folded into something called Focused Education Resources. And what is that? This is not a government body. It is a non-profit society. So it's a private organization that is funded by the government, which is bizarre. Like, Kids First is a non-profit society. This is like it's not part of the government directly. So now we have 2 organizations, private organizations, that collect and pre-approve learning resources. One is Focused Education Resources, which approves SOGI 1, 2, 3 resources, and then we will talk about the ARC Foundation, which provides SOGI 1, 2, 3 resources. The impact of privatizing public education learning resource selection is that non-profit societies do not report to the legislature. Neither do foundations like the ARC Foundation. The salaries of the staff are not on the public record, so there's no transparency and accountability with private societies and foundations. So that's who's choosing the learning materials. There's focused education resources that listing SOGI 1-3 resources. There we go. So what started out as something for the bullying and safety strategy now is for the entire curriculum because of the valuing diversity aspect that was added to the curriculum. So these resources are approved, or they're used, can be used, well, for anything really, but they're especially for English and PHE curriculum, but teachers can use what they want when. So remember, teachers, librarians, and all education personnel can choose resources from SOGI 1-3 or anything else for any subject virtually without restriction in accordance with professional autonomy. They can also invite students to bring in whatever they want and talk about whatever they want. Where in the past, these things were more carefully curated so that there was, because there was more sensitivity to all the diversity that's out there so that it would be a more safe environment for all these diverse people in the classroom. So SOGI 1-3 is produced by the ARC Foundation, which is a private belief-based proselytizing group that the government partners with. This is their belief. Everyone has a sexual orientation, gender, and identity. That is a belief statement that, as I said before, all the terms in there are highly contested. And here's some of their lists about different books and videos and things. Family diversity, LGBTQ plus history, gender identity, young adults, etc. You can look more at those if you'd like. SOGI 1-3 was founded by the government, the BC government, the ARC Foundation, the BC Teachers Union, and activist groups. That's what it says on their website. What is the government? The government never doesn't. Well, actually, they did partner with the churches, didn't they, back in the day? And that was what created the residential schools. The government partnering with belief-based organizations has a history in Canada. And ARC Foundation says that SOGI 1-3 is their number one priority. All efforts on SOGI 1-3. And their focus is schools. Who funds ARC, the ARC Foundation, SOGI 1-3? We do. The British Columbia government and the federal government both fund these organizations. They're private organizations. So what happens, another thing that happened that changed was the introduction of unaccountable third-party educators. So lots of teachers don't want to or can't, for whatever reason, teach so-called sensitive topics in these curriculums. So the districts bring in, maybe for whatever reason, that these districts and schools bring in outside businesses and so-called nonprofit organizations who are paid to do these sensitive topics. For example, Salima Noon's business is one that many families have encountered. Here's Salima Noon, and that's her website. So what's with third-party educators? Well, they are not under the teacher's professional code of conduct. So they don't, because they're not teachers. And they use emotionally manipulative tactics to get kids to open up and trust them while they're there for whatever, an hour or two or so. They have techniques, psychological techniques that they use to get kids to open up when they wouldn't normally, they'd be more reticent to talk about this stuff. And if you actually read the health curriculum, I think, oh, that's okay. But the curriculum is very vague and it's actually not necessarily followed. Salima Noon is not accountable. Those organizations are not accountable. They're not teachers. They are outside businesses. And one tactic they typically use is students are asked to write any question they want anonymously, and that question will be answered. So all the kids in the class will then listen to the question read out by the educator and listen to the answer. Actually, we have no way of actually knowing if these questions are written by the kids or not, because again, nothing accountable here. And so if the kid's asking a question that's not on the curriculum, well, they get answered anyway, I suppose, as I've heard. You can think if you have questions about that section. And we'll just keep moving on to what can be done. Suggestions for action other than legal action, and there'll be suggestions for legal action, which is actually our core goal. So actions, got about 13 suggestions here. One is don't enroll or register your child. Kindergarten is not legally required. The child does not need to be registered or enrolled until they turn 6, the year they turn 6. And at age 16, children are not required to have an education program. So when your child turns 16, you can just check out if you want. So there you go. Just don't do it. This is the BC School Act legislation regarding that age range. Another choice is homeschooling. So our law in BC says that children ages 6 to 15 must have an education program. But in BC, unlike other places in Canada, parents are equal to the province and the school boards in defining the education program. So parents can define the education program under section 12 and 13 of the BC School Act. And that's what's called homeschooling when parents do this. So you want to do this, you are legally required to register your child at any public or independent school. I strongly urge you want to do this to register at an independent school because it'll make it much easier for you. The public schools will drag it out and waste your time. And all you need to do is just tell them you don't need to spend a lot of time filling in forms and interviews with principals. That is not a requirement. It's an offense not to register your child, but sometimes people don't register their child and that nobody seems to really mind. Currently, there's no public funding provided to parents who do homeschooling. And in BC, there are no teacher visits, no tests, no inspections or required studies, and the parents aren't asked about their qualifications because, as we've seen from the human rights law, parents are trusted with the education of their children. If you don't do homeschooling, another option is these things called provincial online learning schools. They used to be called DLs, distributed learning, but I'll just call them PLOS. That's the new terminology here. So most families in BC who say they're homeschooling are actually not homeschooling according to the government. They are in a PLOS program or course. So students may enroll in these PLOS programs or courses offered by districts or independent schools. You don't have to be in your own district or your own catchment. You can enroll in anyone in any part of the province. And these PLOS things have teachers, report cards, and grades. And most of these are online screen-based courses like Chem 11, French 9, or whatever. These are online learning, computer-based learning. I personally don't recommend that as an optimal way to learn, but it's out there. But there are some of these PLOS programs are not online courses. They are parent-led, and they may have in-person classes or workshops or field trips, but there's a great emphasis on parent participation. So these are the ones that a lot of homeschoolers are more likely to be involved in. And so the public district PLOS programs are funded about $1,400 a year less than the regular schools, and the independent schools that have PLOSs are funded at 50% of the public ones, and they may charge fees. Yeah, so you can enroll. You don't worry about your catchment. You can enroll any public or independent or district or independent PLOS. And high school students can cross enroll. So there's a lot of different options here. You could actually go to a public school in your neighborhood and take a PLOS course from another district or independent online thing. You can mix homeschooling and independent, mix things up. So this is called cross enrolling. There's lots of different options here. If you are interested in these, don't waste your time asking your public school counselors and teachers and principals for information. In my experience, they never provide accurate, full information. These are sources of information you can get. One is this is a government website that lists all the PLOS courses and programs here. search.onlinelearningbc.com, search.onlinelearningbc.com. You can take kindergarten online. You can take dance and woodwork and online. They have all these options. Another source of information. Yeah, so you would search the thing you want to do and find out your enrollment options in different parts of the province and find the one that suits you best. So the BC Home Educators Association has a lot of great information. It's at www.bchea.ca. And one thing they also have here is support groups. So if you were interested in these options, you don't actually have to be a homeschooler to join these groups. If you want to join a support group, they're listed there. So get a great source of information. Another thing you can do, number 4 is avoid school counselors and youth workers. Why am I saying that? Well, parent-child conflict is normal. If you haven't had it already, that's amazing. You probably will at some point. Your kid might be upset with you, or you might be upset with them. So we need to develop an attachment village for our children and our family. We need to ensure that our children have strong ties to adults outside of the education system that you fully trust. These could be your friends, your kids' friends, parents, aunties, uncles, grandparents, etc. And you tell your children they can talk to these trusted adults, build relationships with other adults, spend time with your kids and the adults. Don't always keep the kids separate from the adults. Mix it up. Do things together. And the reason we need to avoid school counselors and youth workers are because the BC Infants Act, a law in BC, the BC Infants Act, Section 17, allows registered healthcare providers to decide that a minor can accept or refuse healthcare without parental consent. In BC, you're a minor till you're 19. In some provinces, it's 18. In Saskatchewan and Newfoundland, it's 16. But this is the mature minor concept. But the term mature minor is not in the law anywhere. It's just a term. But because the healthcare provider includes people doing any therapeutic service, would that include school counseling? I don't know. So this Infants Act is also misused to hide minors' health information from parents. It does not say in the Act that healthcare providers can withhold information from parents, but that is routinely done and has been happening for decades now. So some school counselors and youth workers have withheld important information from parents or referred students to doctors or clinics without parental consent or parental knowledge. And there's clinics, they're called youth clinics, other things too, and some doctors. They don't even require parental consent or knowledge from the family GP or even the care card number to be provided. Now, the child, the minor, is able to refuse to consent to or refuse treatment, including addiction treatment. This has resulted in the deaths of children. And the child can consent to surgery or drug treatment without parental consent or knowledge. It's supposed to be, though, anyway, it's misinterpreted. This Infants Act is a huge problem in BC. Basically, it eviscerates parental rights and parent-child rights, and it's in other provinces in a different form. And that mature minor is the term that they'll use. This is the act in BC. You can read it, it's not too long. This section was inserted to the Infants Act, which is a very old act. It goes back to the 1600s, and this was inserted in 1973 and then amended in 1992 and just eviscerates parental rights. So another change that happened was another thing that you can do, is actually use this opt-out option. You can just tell the teacher or the principal, preferably in email, in writing, the beginning of the school year or as soon as possible, and tell them that you want your child to opt out of the health and planning stuff that you don't like, the sensitive issues. Officially, it only applies to those courses, but That's the official thing. Like as if school systems should have power over parents' decisions. Um, so since this opt-out only officially applies to the sensitive issues in health and planning, you could, well, you could teach your children to assert their rights and to leave the classroom. Because at any time, teaching, resources, assignments, presentations, discussions, social scientists' research studies and questionnaires, or posters, or hallway displays, flags, practices, and learning resources may violate privacy and boundaries, violate informed parental or student consent, might create a poisoned learning environment, or make students or parents feel unsafe, unwelcome, excluded, or unvalued. They might violate your rights. So teach your children to recognize when this is happening. Teach them practice respectfully stating their needs and rights, and allow them to leave the class or school. And if you do that, you need to give them a place to go, like the library, the cafeteria, the home, or neighbor. Okay? These are suggestions. You don't have to take any of this to heart. Here's some things a child might be able to learn to say, like from the kindergarten health curriculum. No, stop it. I don't like this. I don't feel safe. I don't feel comfortable. No, I don't consent. This violates my boundaries. This is not inclusive. This is against my family's beliefs. I don't consent. That is private information I won't share. My parents do not want me to share this private information. I need to ask my parents about this. They will email you. I need to leave because this is against my family's beliefs. Another thing parents could do is not pay illegal school fees. There was a case in BC in 2006, a young case where like a school board is not permitted to charge student fees for anything that's required as part of the curriculum. All this must be free. So anything that's required must be free. Anything required to do a course. Now, if the school's like, taking a trip to Paris or something in the summer, that's not required for a course, so they can charge for that. But everything else must be free. So to stop paying all those fees, just tell them no. It doesn't matter what your income is. Don't discuss that. Just say, I'm not paying. It's illegal. Don't charge me. Don't waste your time discussing your economic situation with them. Just tell them, I'm not paying it. Yeah, and there was a case in 2000, that where millions of dollars in tuition fees had to be paid back to families. They were refunded in 2004 to 2006. Legal action has been successful. Another thing I would suggest is that don't do fundraising for schools. Do fundraising for yourself or for other organizations or your friends and neighbors. If you do school volunteer work, choose it carefully. Don't waste your valuable unpaid time. If you want to make hot dogs, I guess you can, but might want to think about not doing that. You could volunteer in a way that empowers your children or other children or parents. Volunteer in a way where you can observe what's going on in the school. Another thing you could do is hand out leaflets and put up posters. Now, there's been court cases in BC where teachers' expression of their political expression in schools on the job has been challenged, and the courts have determined that teachers are allowed to hand out BC Teachers Federation leaflets, wear political buttons at school, and put up posters and things. And so parents and students do not have the same responsibilities as teachers. So why don't you express yourself there too? The court case said that a school is a communication center for a whole range of values and aspirations of a society. The school is an arena for the exchange of ideas and must therefore be premised upon principles of tolerance and impartiality, so that all persons within the school environment feel equally free to participate. Do you? Put up some flags, posters, whatever you like. If they say you can't, just show them this and stand your ground. Another thing parents need to do is take the technology devices away from your children. Kids get addicted to technology. Phone is like cocaine for children. They get emotionally addicted to the the tech influencers, like the peers or the role models and all the talkers on TikTok and whatnot. So kids need to be attached to their parents and trusted adults. If they're attached to their peers more than to you and to the tech influencers, you are not going to have much strength in your relationship with your child. Replace the phones and the iPads and the computer time with conversations, with bikes, rides, hugs, home skills, cooking, reading together, having family and friends over, drawing, basketball, sports, arts, camping. Take them away. And especially keep the technology out of the bedroom. They should not be, texting their buddies or doing TikTok videos all night long. This is very important. And this is about prioritizing the parent-child attachment. And I most strongly recommend the work of Dr. Gordon Neufeld. He co-authored a book with Dr. Gabor Mate called Hold On to Your Kids, Why Parents Need to Matter More Than Peers. There's also the Neufeld Institute. They have some resources that are free. I've linked there. And there's this article about parenting in a digital age. I'll strongly recommend. And another, Dr. Deborah McNamara, is also at the Neufeld Institute. That's her website. She has articles that discuss a lot of these things. And I just stress that you might want to look into these resources. Another thing, you can become a member of Kids First and donate. Having more members helps us in any legal action. And if you donate, you will get a tax receipt for your registered charity. Actually, I'd also like one more suggestion that teachers. In Denmark, there are 4 teachers' unions. Maybe teachers need to make more teachers' unions. Or I don't think all the school staff is totally comfortable with what's going on, but they're silent and they allow what's happening to students to go on. And I'd say they need to stand up. It's a thought. So legal action, what does that look like? So if a staff member's at the school's actions or lack of action, and this would include statements, or a learning resource, a book, website, whatever it is, causes harm, a formal complaint can be made. And harm, define that very broadly, something that makes you feel unwelcome, something that causes, it excludes your belief set or whatever. Define harm very broadly. Each district is required to have policies about the complaint process, and that's called appeal process, and about learning resource selection. So you can complain about, make appeals about learning resources. So the complaint usually begins with the staff involved, for example, the teacher or librarian or counselor, and then you complain to them. Not happy with that answer, then you go to their supervisor, which is usually the principal. This is the principal response. Then you go to the district superintendent. All of this is done in writing. And the superintendent must respond in writing within a set time. So it's not a very long period, something like a month or so, depends on the district. And the written response from the superintendent is called an administrative review. Okay, so if you're not happy with that administrative review, that document can be taken to the BC Supreme Court for a judicial review. So in a judicial review, a judge reviews, looks at the administrative review and decides if they follow policies and laws, and that's where we would also bring in the charter and the human rights laws and the international human rights agreements. And the case would be not just against the district, but against the Ministry of Education and Childcare, because it's the ministry that's causing all these problems, because they've downloaded all these responsibilities to the districts and given basically teachers and staff freedom to do whatever they want in the classroom, not whatever they want, but they've opened up the door to activist politics and indoctrination, if people want to call it that, in the classroom, and a lack of sensitivity to the rights of parents and children. Yeah. So at the BC Supreme Court, a decision will be made. I'm not sure it's called a decision or judgment, but a judge would make a ruling, and one side or the other side would win, or sometimes it's a kind of mix of wins and losses on both sides. But that decision could be appealed to the next court level, to the BC Court of Appeal. So you need to be prepared to go to the next level. And at the Court of Appeal, 3 judges look at that, and they make a decision. And again, that decision could be appealed, and if it's appealed, it goes to the Supreme Court of Canada. So this process can be expensive and take a long time. It's a obviously very high profile issue. And in public interest cases like this one, another thing that happened is interveners. So other groups or individuals may also want to take part in the court process if the case affects them. So groups like faith groups, human rights groups, parent advocacy groups, citizens groups, whatever, could get involved in the court process by being interveners. And they can support either side. Of course, they have to apply to be an intervener. You can't just jump into the court. But having interveners increases the court costs for time and also for the official copies of the court documents. And those costs you can't minimize. There's a set fee and it's quite high. So that's something about the process. You might know a group that would be interested in being an intervener. But what we're looking for is complainants. Legal action requires only one person, preferably a few people, to be complainants. We were thinking maybe 5 to 15 people to be the complainants. And is this you? Could you be a complainant? Complainants could be parents or students, family members, or school staff. We'd like you to think about this. And if you're interested in being a complainant or thinking about that, contact us at info@kidsfirstcanada.org. We're looking for complainants, to select complainants to represent different groups from society, different ethnic, cultural, religious groups, different situations at a school, and different school districts. And complainants, you will need help from the very first step, and we will give you help from the very first step. Because the very initial complaint, like when you go to that teacher, it must be comprehensive. It must be comprehensive because you can't bring in complaints, other issues later on. So, oh, I forgot to mention that this was a problem. But you have to have all in at the beginning. So we can help you with that process. And then the complainants, they're the ones who retain, that means hire, and get advice from and instruct lawyers. And complainants' main task is to write affidavits. That's a sworn written statement, and they would do that with the lawyer's help. So they describe their situation and their background and what happened in the affidavit. And that's what is looked at in court. Privacy can be a concern. Usually cases involving minors, the names are changed, like that BR case. They don't publicize the whole name. But it's possible that when the children are over 18, the names will be in the public record. This is not totally sure, but how this actually works out. There's some concern with privacy. If you weren't a complainant, you can still use your help, be a helper. We need people to do things like donate, for technical support, to raise funds, to inform others, to do media, to provide practical help to complainants, and to encourage the complainants and to encourage each other. So education that respects diversity, inclusion, and equity for all is possible. We use our imagination. I mean, every child in this province is entitled to a free education that respects and honors them. And parents have the authority over the education and moral upbringing of their children. We saw that from the Supreme Court of Canada and the Convention on the Rights of the Child and all those other human rights agreements. So how about providing equitable public education options that are inclusive of all by respecting both diversity and parental authority? So thank you. I hope this has been informative, and Again, our contact email is info@kidsfirstcanada.org. If you are seriously considering taking legal action, please contact us and we will help you to meet with lawyers and help you with the complaint process. Thanks. Think of your questions. So I'm going to stop sharing there. And just, yeah, again, thank you for listening to this. And please feel free to share it with anybody who would like to learn these things. Thanks. All the best. By the way, my name is Helen Ward. I'm the president of Kids First Parent Association of Canada.